All right, ladies and gentlemen, you're watching Safer Arizona Wire. I'm your host, David Stephen Wisniewski.
And I'm Tom Dean, attorney for cannabis.
Today, we are talking about severe shortcomings in Prop 207. But before we get into that, I want to let everyone know that despite the risk areas, I believe that 207 is still a better situation than the current prohibition. It makes 1 ounce of flower legal. Of that ounce, 5 grams may be in concentrate form. It improves the DUI situation and provides some expungement. With that said, we have been loud advocates for correcting 207 with another initiative for the 2024 election ballot. And the following is a list of areas we must improve on and an explanation of why it's so important to get something better as soon as possible. We expect Prop 207 to pass, and the following are severe risk areas where people could end up in a lot of legal trouble, and the purpose of this show is to identify those areas so people have a better understanding of their limitations under Prop 207. Now, first and foremost, what's the underlying problem with this initiative is it does not repeal or amend the criminal code. Now, Tom, can you go into what the criminal code is and why it's important that that should have been amended?
Well, yeah, ideally, the criminal code is what makes marijuana illegal in the state of Arizona. It makes it illegal to possess it, use it, grow it, transport it, import it. And that's without amending that criminal code directly, you're always going to run into a problem where when the rights and privileges that are afforded in any legalization initiative are exceeded, in other words, for example, you're in possession of more than you're allowed to be in possession of, then it's going to revert back to the criminal code. So just to give a quick illustration, under Prop 207, you're allowed to carry around 1 ounce of marijuana, up to 1 ounce, and that's perfectly legal. If you possess more than 1 ounce, but no more than 2.5 ounces, then that's called a petty offense, a very low-level misdemeanor offense. However, and that's a great improvement because right now it's a felony. So 1 ounce is legal, between 1 and 2.5 ounces is a petty misdemeanor. That's a huge improvement from a felony. But if you possessed more than that 2.5 ounces, now you're back into the criminal code. You're back into a felony charge.
In other words, they don't repeal the prohibition in the background. They place this law on top of prohibition. So whatever is covered under Prop 207 is legal, or they prescribe other penalties. But once you violate that law, you default back to the still existing prohibition where everything is listed as a felony.
Right.
So there's a couple of differences between the intent of the initiative and how things actually play out. And a lot of times a campaign will come out and say, this is how the initiative is supposed to work, but then you end up going to court, and sometimes it could take years before it's actually cleared up. I remember the medical marijuana program came out and people weren't selling concentrates right away, and it had to end up getting litigated before people were comfortable and they were selling concentrates in dispensaries. But in this initiative, there's a couple of things that are ambiguous that we're not sure which way they're going to go until they end up getting litigated and going to court. So the first thing I have on my list is parental rights. Parental rights are ambiguous and may not be applied. Now, Tom, can you explain that a little bit further and how it might end up playing out once this passes?
So the campaign, the Smart and Safe campaign behind Prop 207, has said over and over consistently that their intent was to protect parental rights. What are parental rights? That means that custody and visitation can't be interfered with by the courts because one of the parents is a cannabis consumer. In Arizona, before the Medical Marijuana Act, pretty much any parent who was caught with marijuana, it was sort of presumed that they were involved in child neglect by definition. That improved a lot with the Medical Marijuana Act because the Medical Marijuana Act, for patients, it has a specific provision that says that custody and visitation cannot be disturbed absent a proof by clear and convincing evidence, which is a pretty high standard,
and
that
even
the parent's
though
medical use is an unreasonable danger to the child's safety.
Even though the Medical Marijuana Act had provisions that helped parental rights, it still took a long time before that was even implemented by the Department of Child Safety.
It was resisted by the dependency court system, and they didn't like the idea and couldn't really at first even believe that it could possibly limit their power, because they really do have a tremendous amount of power over there. And it took some time before they finally had to accept that indeed they were subject to the Medical Marijuana Act.
And so we expect something similar to happen here with Prop 207, that it could take a while before we see the protections being enacted. Now, under the Medical Marijuana Act, they have actual protections for parental rights, but this has like a blanket statement that's just supposed to protect all your rights.
Yeah, it doesn't have any provision that specifically references custody, visitation, or parental rights. It does have what they want, what they hope will be interpreted by the courts to be a broad grant of rights and protections that would also apply to the rights of a parent. And it's the terminology, from what will become the new ARS 362852 states that, notwithstanding any other law, the following acts by an individual who is at least 21 years of age are lawful, and this of course includes possessing and using marijuana, are not an offense under the laws of this state or any locality, may not constitute the basis for detention, search, or arrest, and cannot serve as the sole basis for seizure or forfeiture of assets, for imposing penalties of any kind under the laws of this state or any locality, or for abrogating or limiting any right or privilege conferred or protected by the laws of this state or any other locality. So a parental rights would be in that last part. So it's saying that the use of marijuana under this act cannot where did I go here? I lost my place. Cannot be used as a basis for abrogating or limiting any right, which would include parental rights, or privilege conferred by the laws of this state. Again, that includes parental rights. So it's included, but it's a very broad statement. And the troubling part is, with that kind of broad language, not specifically being directed towards parental rights, will parental rights be protected? Will that provision be interpreted the way it's meant to be interpreted by Smart and Safe, which is that custody and visitation rights won't be disturbed based solely on a parent's choice to consume and possess marijuana?
I would say the answer is I don't know, but there is a chance that this is all-encompassing and it could be totally covered.
I feel that it will work. I know how I would argue it, and I think I could win in stating that parental rights are protected under that broad statement. But we expect, though, that there might be some pushback from the government about exactly how far that goes.
All right, next. Possession above 2.5 ounces of flour.
Right, and we touched on that. I used that as an example earlier.
So 2.5 ounces, 1 ounce to 2.5 ounces is a petty offense. And is that a misdemeanor?
Yeah, it's a lowest level misdemeanor.
And then you go above that, you fall off under the existing felony prohibition.
Right.
Now, possession of above...
So in other words, just be clear here. Possessing 2.5 ounces of marijuana is a petty offense, the lowest possible type of offense, criminal offense. But if you then got caught with 2.6 ounces, that's a felony. So you go from, basically the most minor type of situation to the most major type of, from petty offense to felony. And so people have to be really careful not to go higher than that, because it could be problems.
And then now next we have possession of above 12.5 grams of concentrates. They make 5 grams legal. And I want to make this clear, it's not 1 ounce plus 5 grams. It's 1 ounce total, and of that 1 ounce, 5 grams may be in concentrate form, and then 5 grams to 12.5 grams is a petty offense. But then once you go above 12.5 grams, you fall onto the existing prohibition. Now, if I'm not mistaken, that's a more serious felony than going over your flower allotment, the concentrates.
It is a possession of marijuana is a class 6 felony. It's the lowest level felony. Possession of concentrates, extracts, is classified as a narcotic drug under Arizona's criminal code. That's a class 4 felony, so it's a higher level felony.
Now, we're talking about these felonies, but I don't really hear a whole lot about people actually getting stuck with these felonies. And I remember you were telling me there was another proposition, Prop 200, that kind of gave you a different option. Can you tell us a little bit about how Prop 200 interacts with with marijuana charges?
So Prop 200, among other things, established that for the first 2 possession-only offenses of any substance, the person cannot be incarcerated. So it's mandatory probation. Now, that later was the voters of Arizona agreed to exclude methamphetamine from that. So possession of methamphetamine doesn't fall under Prop 200. All other substances do. So for simple possession, it's mandatory probation for the first 2 offenses. And so even if you were convicted, let's just say you ended up in possession of 15 grams of wax, that would be over the amount, the petty misdemeanor amount under Smart and Safe, and you would then be subject to a Class 4 felony. However, even if convicted of that Class 4 felony, probation would be mandatory if this was your first or second offense. The only exception to that is if you have a felony crime of violence on your record. So if you did like an armed robbery, then Prop 200 doesn't apply to you. So as long as there's no felony crime of violence in your past, then those first 2 offenses for marijuana or marijuana concentrates are mandatory probation.
And now that we're on this topic of concentrates, 12.5 grams, I want to point out that Maricopa County Attorney, what's her name?
Adele.
I don't know her last name, but there's a new policy out that states that if you would have been compliant under the Medical Marijuana Act, but you didn't have a card, once you got arrested, you can apply to get your medical marijuana card. And if you get it, then you can get your charges dismissed. So not only Prop 200 might help you avoid a felony, but if you're under the medical marijuana limit, which they allow you to have more than 12.5 grams of concentrates, that's another way to avoid that felony is to get your card and get it dismissed. But that's only in Maricopa County. It's not statewide. However, I think about half the citizens of Arizona live in Maricopa County.
Yeah, and since we're on that topic, so she's saying that as long as her policy now is that went into effect this past Friday, is that as long as you would have otherwise been in compliance with the Arizona Medical Marijuana Act, except that you didn't have a card. If you later go and get the card after you get busted, then they'll agree to dismiss the charges. So what does that mean? Well, we know the allowable amount under the Medical Marijuana Act is 2.5 ounces. So what it really means, once Prop 207 passes, we know that anything up to an ounce, that's totally legal. Between an ounce and 2.5 ounces, that's a petty offense. So what they're saying is, instead of the petty offense, we'll just agree to dismiss the case. But if you're over 2.5 ounces, now you're gonna be subject to their regular policies, which would normally include, as long as it's not much over 2.5 ounces, you could either do like a deferred prosecution, what used to be called the task program, or you could plead guilty to a misdemeanor possession of marijuana. And that probably applies up until you get closer to, a pound, at which point they may not be willing to allow you to do a deferred prosecution. They may be talking about, undesignated felonies, but I don't want to get too complicated.
Well, next, we have cultivation above 6 plants.
Yeah.
Six plants is legal, but if you go over 6 plants, you fall onto the existing prohibition.
Well, right. There is no buffer here like there is for possession of marijuana and possession of the concentrates. So if you go over 6, you're immediately in felony territory. So if you're, have 6 mature plants and say you have a couple clones, then that takes you over your plant number and you're subject to felony prosecution. The thing that's most concerning, and some of you might remember this being talked about back in 2016, is if the total weight of those plants is 2 pounds or more, then you're facing mandatory prison if you're convicted. Now, of course, we're not talking about a plea deal or anything like that. But if you were to go to trial and you were convicted as charged, the judge would have to sentence you to prison if the total weight of those plants was 2 pounds or more.
Next, here's where it gets dicey. It's possible to get multiple felonies if you end up breaking the law. For example, let's say you have 2.6 ounces, you go above the petty offense and you fall under the prohibition, and you have some, for example, bags, containers, papers that are wrapping your joints, grinders, scales, pipes, bongs, used pen cards. All of those are now going to be considered illegal, and they're going to try to hit you with felonies for every single one of those things. So just by going over a little bit, if you get caught, you can end up being hit with multiple felonies.
Yeah, so let's be a little bit more specific. Let's say that you were in possession, they found you to be in possession of 3 ounces of marijuana. And of that 3 ounces of marijuana, maybe, say, 5 grams was in a concentrated form, like it was wax, for example. In that case, then you would be over your allowable amount, chargeable as a felony, because we're past the petty misdemeanor category. So the marijuana would be charged as a felony, and you would also be over your concentrate, even though it was only 5 grams or 4 grams or whatever, because that's part of a combined weight. So once you're over the combined weight, then they're going to certainly, we're going to have to fight this, but they're going to definitely, I think, argue that you're subject to prosecution for both felony possession of marijuana and felony possession of narcotic drugs, the narcotic drug being the concentrate.
And that's how it is right now under the medical marijuana program. Once you violate the law, you have no protections under the law.
Yeah, now it's not quite like that though, because let's say because under this act, and I know we just touched on the fact that you're allowed to grow 6 plants at home. So under the Medical Marijuana Act, once you're over your allowable amount, which is 2.5 ounces, you lose all your protections under the Medical Marijuana Act. So that would mean that if you were authorized to cultivate, that all of a sudden would be illegal. So not only by being in possession of more than you're allowed to have, all your marijuana activity becomes illegal. So now you can be prosecuted for production of marijuana as well. But that's not the case under this initiative. If you were found to be in possession of more than your allowable amount of marijuana, and some of that was in the form of concentrate, you would be subject to prosecution for that possession, but you would not be subject to prosecution for the 6 plants. And that's because that's a separate, the plant count is not combined with allowable amount. The concentrates and the flower are tied together in the definition. So you're allowed to possess 1 ounce of marijuana, of which 5 grams can be in a concentrated form. It doesn't say anything about plants. So you could be subject to prosecution for the possession of both the marijuana and the narcotic drug, but you wouldn't be subject to prosecution for the plants you're growing, unless you're doing something illegal there. So as long as you're in compliance there. And the same thing, it works the other way. If you were, say, had 7 plants at home, and then you get busted, and you're prosecuted for felony production of marijuana, as long as you weren't over your allowable amount, and on your person, you're not going to be charged for that. So it's not as bad. It's not really the same as the Medical Marijuana Act, where you lose all protection. But in the case of possession of concentrates and marijuana flower, then yeah, you could be charged with both if the combined weight is over the allowable amount.
All right, next. The harvest protections seem ambiguous and may not be applied. Now, the initiative and the campaign have language that the Medical Marijuana Act doesn't have that says you can keep the marijuana that you grew at your house. That's clear to me, but it seems like it could be litigated and could be problematic.
Well, yeah, because it's a little ambiguous, and I'll read. I'm going to read that provision in case you haven't already, just so you can see how maybe unclear it is. So you cannot be arrested or prosecuted for possessing, transporting, cultivating, or processing not more than 6 marijuana plants for personal use at the individual's primary residence, and possessing, processing, and manufacturing by manual or mechanical means, including sieving or ice water separation, but excluding chemical extraction or chemical synthesis, the marijuana produced by the plants on the premises where the marijuana plants were grown, if all of the following apply. Not more than 12 plants are produced at a single residence where 2 or more individuals who are at least 21 years of age reside at one time. B, cultivation takes place within a closet, room, or greenhouse or other enclosed area on the grounds of the residence, equipped with a lock or other security device that prevents access by minors. And C, cultivation takes place in an area where the marijuana plants are not visible from public view without using binoculars, aircraft, or other optical aids. Now, when I read through that provision, nothing jumped out at me to say, and you can keep all the marijuana that you grew or harvested from that grow. But if you read it very carefully, it can be argued that it should be interpreted that way. It's just that likely this is going to result in litigation, and this is going to have to go up through the appellate courts before we know for sure whether that very broad and ambiguous language is going to be interpreted the way that the Smart and Safe campaign is saying that they intend it to be interpreted.
Now, it could be solid, and it could be totally fine.
Yep.
But we're erring on the side of caution. It looks ambiguous, and we know from the Medical Marijuana Act that not everything ends up being interpreted the way they intended on it. From what I understand, they didn't intend on the 25-mile rule to be a restriction for people, but the state interpreted it as such, and now we're stuck with the 25-mile rule. So there is a big difference between intent and real-world application.
And I know we've got a couple other things to talk about.
We got to take a quick break. We'll be right back. Don't go anywhere.
Hi, I'm Tom Dean, attorney for cannabis. You may know me for my work here in Arizona in important cannabis-related matters like the ASU campus ban case or the cannabis concentrates case, State v. Jones. I've been representing cannabis consumers for 26 years now, and for the last several years, I've been doing nothing but that, representing people in important criminal and DUI cases related to the use of marijuana. If you've got a case involving criminal charges, or if you're just looking for advice or wanting to enter the Arizona's cannabis industry, please give me a call. You can reach me at 602-635-4990, 602-635-4990, or visit me on the web at attorneyforcannabis.com.
And we're back. We are talking about some shortcomings in the 207 initiative, and last thing we left off with was there is a huge difference between intent of the initiative and how it plays out in the real world.
Yeah, there's the reason why we're talking about this today, really 2 reasons. Number one, we want people to be aware ahead of time of these issues so that you can exercise caution.
We don't want you to get arrested.
You don't want you to be the guinea pig who has to find out whether this law is going to be interpreted one way or the other. So be careful, in other words, not to possess more than you're allowed to have. Be careful not to grow more than 6 plants. And if it's me, I'm definitely probably not going to try to amass as much marijuana as I can harvest at my home until it is established by the courts clear, that indeed you can do that. So for those of you who want to err on the side of caution, and we're just giving you these areas where you want to be mindful of so that you don't end up getting in trouble until all of this gets settled.
And it could end up being easy to get in trouble with this next topic.
And the second reason, though, because
Okay,
there's two
hold on.
reasons.
I'll hold on a second.
Hold on there, Dave. The second reason is that we also want you to know these issues or shortcomings because, again, it's important that in 2024 we're able to correct a lot of this. So those are the two reasons why we're really talking about these things today.
We want a better initiative later on. But first, past this one. Now, it can be easy to end up breaking the law. There's a concept called looping and dispensary hopping. This initiative allows dispensaries or marijuana establishments, whatever they end up going to being called, to sell 1 ounce per transaction. This means you'll be able to go in, buy an ounce, and then let's say you consume the whole ounce right away, you'd be able to legally buy another ounce because you consumed that ounce already. But how does the bud tender know you consumed that ounce already? In Colorado, they had a problem where the same person would come back multiple times a day and buy an ounce over and over and over again. Since the dispensary is allowed to dispense 1 ounce per transaction, they kept doing it. Now, I think some dispensaries got in trouble for that, but if you're not looping, you can also what they call dispensary hopping, where you go from dispensary to dispensary to dispensary, and there's not a system that they put you into like the medical marijuana program that says how much they've sold to you. A dispensary won't sell you more than 2.5 ounces of marijuana because they track how much marijuana they sell to you in any given 2-week period of time. That's not going to happen with the adult use initiative. So you can go from one dispensary to another and easily, legally put yourself into an illegal situation.
Yeah, you know, you're going to have to. You're responsible for your own actions. You can very easily, under this act, end up possessing way more than you're allowed to have either by growing it and taking it with you outside the home, or by going and buying it, dispensary hopping, and heck, in one day it could very easily in the greater Phoenix area end up with probably a couple pounds, I would imagine, once everything's up and running, by just going from dispensary to dispensary.
It'd probably be pretty expensive, but they will provide that much weed if you dispensary hop. And I'm not advocating for that.
Right.
I'm just saying
it's not a defense to say that you legally bought it.
Right.
Right.
Well, so don't dispensary hop, don't go over your amount, make sure you're staying within your limits. Now, there's going to be a time when it's legal to possess your ounce, but there's not going to be any marijuana establishments delivering marijuana to people. So how are people going to get their marijuana? One, they can grow it if they have it in a closed lock facility, and they can give it to each other for free if they end up obtaining it already. Now, I don't think we've talked about this, but and I just thought of this right now. Do you think it would be legal for a person to go to a dispensary, buy an ounce of marijuana, and then give that for free to an adult use person?
Yeah, that is legal under this Prop 207. You can transfer marijuana to another adult over the age of 21 as long as there's no form of compensation. Nothing of value is given in return.
So there's going to be ways to get marijuana before the marijuana establishments open, but there's going to be a lot of, it's going to be an enticement to go ahead and try to buy it off the street, which will still be a felony. Now, I'm going to go ahead and skip ahead to that. Unlicensed sales. That is not covered under this initiative. I know alcohol, if you sell beer to someone without a license, it's a misdemeanor. But here, since they don't cover it, it resorts back to the criminal code, and you're still looking at a felony for unlicensed sales. Next, will the market meet the demand? That's another thing. I think eventually it will, but in the beginning, I think they'll have some catching up to do. So before the market catches up to meet the demand, there might be a motivation to go to the black market and commit a felony. You might end up getting in trouble trying to get it from the black market. So you're going to want to find those legal avenues. And I know no one likes to give marijuana away for free, but that's going to be one of the ways for you to get it legally, is if you get it for free from another adult. And then cultivating marijuana. But cultivating is also has a risky area. If it appears in the initiative that if you don't have a lock on your marijuana that makes it impossible to be accessed by minors, that you have no protection under the initiative. So it could end up being a felony if you end up cultivating it and minors can still access your grow.
That's right. So not only if you go over plant count, can that, trigger a felony prosecution for production of marijuana, but if you don't have the marijuana, if it's not locked or equipped with other security devices that prevent access by minors. So if there's, what are other security devices? I mean, I've heard a lot of people. Could it be security cameras? Could it be a guard dog? I know
That'd
one
be
guy.
pretty hardcore.
One guy had attack peacocks that he used to guard his greenhouses out in a rural area in Apache County. Does that, what counts other than a lock? What are other security devices? I mean, that's a case-by-case thing.
So my question is, if I don't have kids, do you think the courts will say that my front door is a good enough lock?
Yeah, if as long as no minors are allowed into the house, if the front door is locked, then that should be good enough. I mean, let's look at again, all we got to do is look at the language. It says cultivation must take place within a closet, room, greenhouse, or other enclosed area on the grounds of the residence, equipped with a lock or other security device. So could the entire residence be considered the room or other enclosed area on the grounds of the residence? I don't know. I think it's a little risky because it does say on the grounds of the residence. It says an enclosed area on the grounds of the residence. It doesn't say the entire residence. If it were me, I wouldn't, until that was settled crystal clear, I would not assume that my entire house could be considered the legal grow room, and all I got to do is make sure the front door remains locked, and I never let anyone under the age of 21 come in. So I think, though, that any part of the house certainly could be the room or the enclosed area. So again, it's not exactly clear for sure. So that's why we're talking about this today, just so you're aware of that fact.
Well, again, the underlying problem to almost every situation here is the criminal code. So in the future, what we'd like to see in a 2024 initiative effort is attacking that criminal code. I'd like to repeal it altogether, but some people like to see penalties for certain things. I don't like to see penalties for certain things, but at least taking those felonies away. It should never be a felony for a marijuana offense, and because they don't repeal the criminal code, we see these problems here. Yeah. But moving forward, I think we've covered every topic here. I think we're pretty much done with the big hot spots here. And again, despite these issues, I do believe 207 is still a big step forward from our current prohibition that lists everything as a felony on the books. And it should pass, but once it does pass, we should push for another initiative that brings even greater cannabis freedom to Arizona.
Yeah, I mean, it may take it. I know there are some people out there, purists, idealists, who would like to say, I want a marijuana legalization initiative that is perfect, that completely legalizes marijuana, just like I don't know, petunias.
We tried that in 2018.
Or tulips.
Tom helped draft it. We ran an initiative that had unlimited possession with a transaction privilege tax license that was unlimited cultivation. It was a completely free market. We tried it. We were as loud as we could. We got 75,000 signatures. And so since we failed, this is what we're dealing with now, but we're not giving up, and we want to keep pushing for the real deal.
And 2016, I think the cannabis consumers in the state of Arizona decided that it just wasn't good enough. And let's face it, the reason that initiative failed was because it lost the support of the cannabis consuming community. And I think that's because it was the worst, and there was a lot of problems. Most of those problems have been fixed in this initiative. And, we made very strict demands to the Smart and Safe campaign that were non-negotiable. And they met those strict demands. They didn't go quite as far as we wanted them to. We wanted total defelonization of all nonviolent marijuana offenses, sales, everything. They didn't go that far. But
they did give us some big improvements.
They gave us some huge improvements. This is a much better deal than what was being proposed in 2016.
I want to talk about
And
expungement for a second.
Okay, let me just finish this point though. We decided, I think, as a community, that we were willing to wait. We were willing to wait and pass up the opportunity for legalization because the initiative was so bad in 2016 that many consumers decided, I'm willing to wait and for something better. Here, to something better here, to pass on this, I think would be a great mistake. I don't know how long it would take before the Arizona voters are ready for like a total legalization. In my opinion, we need to do this in steps. They're going to want to see this passed, and they're going to want to watch what happens for 4 years before they're ready to take the next step, and then the next step after that even. As we move the ball down the field, one first down after another until we're in the end zone. And this is definitely a first down. So that's why it's important, I think, critical that we pass this initiative this year, because I think progress is dependent on this first step. Otherwise, I'm afraid we'll be back here with nothing better 4 years from now.
Yeah, I can see that happening too. And you know why I think that would happen is because it already did happen. Prop 205 failed in 2016, and 4 years later we had an initiative that was better, but it still had a lot of the same problems. And I want to be the next step. I want to be further along in 2024. I don't want to be right back here looking at the same thing in 2024.
Right.
And something we have better here than in 2016 is the expungement. Now, the initiative doesn't actually say anybody's going to be released from jail. But Tom, didn't you say that you suspected that because you don't have to complete your sentence to get your record expunged, that there's a potential that you might get out of jail?
I think there's at least an argument, and this is not what the Smart and Safe campaign was intending. But I think there may be an argument that people who are on probation or in jail or in prison even, because there were 254 people in prison last year for simple possession of marijuana, actual prison, that they may be able to get their sentence terminated early by filing for an expungement, because it doesn't, I don't believe, say here that you have to wait until your sentence is completed. That's maybe a stretch, but it's certainly an argument that you can expect that I'm going to be making.
Well, there's a couple of other stretches that I like. Now, when it comes to possession for patients, now, don't you think that there may be an argument that a patient can possess their 2.5 ounces plus their recreational ounce?
That is, I think, a stretch, as you said. There certainly could be an argument that, hey, I'm allowed to possess 2.5 ounces under the Medical Marijuana Act. And as an adult over 21, Prop 207 says I'm allowed to possess an ounce there. So
it says my rights are not restricted. So why don't I have the rights of the recreational law either? I mean,
Right.
this marijuana is my medical marijuana right. It has nothing to do with adult use. I bought this from a medical dispensary.
Right.
So why can't I also go get my ounce from a marijuana establishment?
I mean, I think there's an argument there. That's definitely going to be resisted. So
At the same time, I would say it might be a stretch, but it's something that I think would be cool if it played out, that a patient who can grow their 12 plants might be able to grow their 6 plants on top of that. But it's definitely a stretch.
It's a stretch. Here's something that's not quite as much as a stretch. Let's say that you have a husband and wife, and they're living in a home together. The wife is a medical marijuana patient. Let's say they live out in, I don't know, Seligman or something that's outside the 25-mile zone. So she's allowed to grow 12 plants under the Medical Marijuana Act. And let's say the husband, he's not a patient, but he's over 21 and he wants to grow his 6. Now, this 207 says that you can't have more than 12 plants per household. Under that scenario, you would have 18 plants, but 12 of those would be medical, and 6 of those would be under Prop 207 by the other spouse. So I think there's a much better argument that would be legal under the combined Medical Marijuana Act and the 207, because 207 is very specifically says it will not in any way restrict or interfere with anyone's right as a patient or caregiver. So if that's true, then that should be okay. So,
Good news is it looks like we're getting some cannabis freedoms. The bad news is it looks like a lot of it's going to have to get litigated before it's settled.
yeah, I mean, something that's not going to have to be litigated is the fact that you can walk around with an ounce of marijuana. That's not going to have to be litigated. That's clear. And that between 1 ounce and 2.5 ounces is no longer a felony, but a petty misdemeanor. That's clear. There's no debate about that. That's not ambiguous. So that's a huge, that's the big improvement. And what's not unclear is that everyone can grow 6 plants, and that you can have at least 12 plants per household, or that you can have up to 12 plants per household. That's not ambiguous. That's not going to have to be litigated. That's clear. So, but some of these other aspects, how far do your rights and privileges go? Because we know people are going to test those limits, and there's going to be litigation about some of those issues.
Another area that it's better than Prop 205 is that Prop 205 had a provision in their local control section that said that they could ban their home cultivation if they considered it to be a nuisance. That is not in this initiative, so it looks like the home cultivation is guaranteed and people are going to be able to grow. But I urge you, make sure that you have a lock or security device that makes it inaccessible by minors. Otherwise, you're not legal to grow.
Yeah, and that, by the way, was one of the demands that we made that were non-negotiable to Smart and Safe on behalf of the cannabis consuming community. And we had big meetings about this. They were very well attended, that we discussed these, and everyone agreed that these should. And one of those was that home grow had to be guaranteed and could not be restricted or prohibited by the local jurisdiction. And so they did that because we told them they had to. Interestingly, the industry can be restricted by the local government. The local government can prohibit marijuana establishments unless they are a dual license. So if it's a dispensary that's already located there, they can be also a marijuana establishment, and the local jurisdiction can't get in the way of that. But as far as anyone who's not already a dispensary, those can be prohibited. Those can be restricted. So not so, though, with the individuals grow.
Well, all right, that's all I got. I just want to remind everybody to know your limitations and be safe, but vote yes on this initiative. We got to pass this so we can get something better going on in the future. Tom, do you got anything else you'd like to add before we conclude this broadcast day?
Just that I'm really excited for November, for Tuesday, first Tuesday in November to come along, because once we get this passed, this is going to mean so much suffering is going to be avoided. So much marijuana, it's being convicted of arrested, prosecuted, convicted of a marijuana offense is bad enough, but it's often used as an excuse for law enforcement involvement in individual lives, the odor of marijuana, that sort of thing. This is going to so dramatically improve freedom in the state of Arizona for not just those who choose to consume marijuana, but for everybody, in the form of a reduction of law enforcement involvement in individual liberty. So I think regardless of whether you choose to consume cannabis, should be a definite yes vote for you, because this is a vote for individual liberty, restricted, limited government. And I think that's what's most important to most people in Arizona. So everybody should be on board with this. This is, and a vote yes for this is a vote yes for freedom.
And I just want to point out real quick, a lot of people like to say that it's a lot harder to change it. You just got to get it right the first time. Well, my response to that is the underlying problem is prohibition. Whether this passes or fails, if you want to improve it, you need another initiative. No matter what, at this point, you need another initiative.
That's all.
So if it passes, we get another initiative. If it fails, we get another initiative. The action is the same, another initiative. It's all the same effort, so it's not harder. It's the same exact effort. It's another initiative.
But hold on, it's even better though, because in here it specifically says that the Voter Protection Act is not going to interfere if the legislature decides that they want to reduce further or eliminate any marijuana offense beyond what this act provides. So the legislature is free to make this even better if they want to, Or, as Dave said, we can do a new initiative in the future.
Well, that's
And
a
I've heard
possibility. I mean, sometimes
sometimes they can
lawmakers.
have, things are changing. The demographics are changing, and you know, like Dave said, I've heard too. Some people say, "Oh, once you get an initiative passed, you're stuck with that." That's not true. Proof of that is the fact that we passed medical marijuana in 2010, and now we're about to pass legalization in 2020. So that's proof right there that you can improve the law with a new initiative.
And at the same time, we did mandate testing and have the cards extended
The
to
legislature
2 years.
did. Yeah, there have been improvements.
So it does happen.
Yeah.
It's slower in legislature, in my opinion, and I think a faster and more effective way to get it widespread improvement is a ballot initiative.
And I don't want to wait 10 years.
I don't want to wait 10 years, but I do want to start drafting another initiative really soon and try to get it on the 2024.
As soon as this passes, you're going to hear Dave and I talking about the new 2024 initiative. It's going to be great. It's going to be another big step forward.
Now, we're going to push, but I just want to make it clear there's no guarantees, and so it's not a reason to say, oh, I'm going to vote no and wait for Safer Arizona 2024.
No.
Same thing happened in 2016. We pushed for an initiative, and we ran an initiative for 2018, but we were not successful. So I just want to say we're going to try as hard as we can, but we weren't successful in 2018.
And I'm telling you right now that if this 207 doesn't pass, the next one that we see that makes it on the ballot is going to basically be the same thing. Maybe some minor improvements, but in my opinion, this is a hurdle that we have to get past. We have to get the first legalization initiative passed, and now's the time to do that.
Then we'll have a free and clear shot in 2024. That's all I got. Tom, do you got anything else?
No, take it out.
All right, until next time, this was Dave Wisniewski
Tom Dean, attorney for cannabis.
with Safer Arizona Wire.
Hi, I'm Tom Dean, attorney for cannabis. You may know me from my work here in Arizona in important cannabis-related matters like the ASU campus ban case or the cannabis concentrates case, State v. Jones. I've been representing cannabis consumers for 26 years now, and for the last several years, I've been doing nothing but that, representing people in important criminal and DUI cases related to the use of marijuana. If you've got a case involving criminal charges, or if you're just looking for advice or wanting to enter the Arizona's cannabis industry, please give me a call. You can reach me at 602-635-4990, 602-635-4990, or visit me on the web at attorneyforcannabis.com.